The defendant, Mr. Johnson, was homeless and transient at the time of the offense, creating a complex legal dilemma. While his attorney argues he was trying to comply but faced immense challenges, the judge emphasizes the grave responsibility of the law, the public's right to know the whereabouts of sex offenders at all times. In a tense sentencing hearing, the court grapples with a difficult question: is prison the right solution for a homeless man who admits his guilt, or does the community's safety require a stricter punishment? Watch as the judge delivers a final sentence that balances the law, public safety, and the unique circumstances of the defendant.
All right, the defendant is present with Mr. Wilkerson, his attorney, and the state's attorney. Earlier, the defendant pleaded guilty to failing to comply with sex offender registration requirements, a second-degree felony. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Any corrections or changes to it?
Nothing from the defense, Your Honor.
Nothing from the state.
Then it's made a part of the record for all purposes. Thank you. The agreement is whatever sentence shall not exceed a cap of 4 years in prison. So it's a second-degree felony. So we're looking at no less than 2, no more than 4 years confined. I guess deferred or unadjudicated probation is an option.
Is an
court,
option.
up to 10 years. Regular probation.
Yes, sir.
So he could be sentenced no less than 2, no more than 4 years confinement, and then suspended and placed on regular probation. So up to 10 years. So those are our options. Go ahead, Mr. Wilkerson.
Well, Your Honor, I think the most important thing to note about this
Well, how much time has he done too? I guess that's important for us to know. You've been in jail a while?
Oh, about 17 months, sir.
Well, he's eligible to get out.
pretty much.
Okay. If he's sentenced to 4 years, right? It's in half. It's going to be a quarter.
It's true. Yes.
Parole in a quarter, which is in 1 year. Okay. Go ahead.
So, Your Honor, I think the most important thing to note about this case is that Mr. Johnson was transient at the time of this incident. He had just gone past his birthday registration deadline by a couple of days. He had, obviously, there was one driver's license address that did not match the address he was registered at. He advised his
500 days. 495.
Yes. He advised his registration officer of an address that he was attempting to acquire at the time. The officer called the complex and he had not submitted a lease at that time. I believe he was residing with someone in that complex and was attempting to secure a lease to those premises. But Your Honor, again, Mr. Johnson was essentially transient, sleeping from place to place where he could find shelter for the time being, including up to and including a house that had burnt down and was abandoned across from the car wash that where the address had been registered. That gentleman confirmed that he had been receiving mail there. I believe he was allowed to use that address as registration previously, based on an agreement with that gentleman who owned the car wash. And so, Your Honor, in this case, I think that while the offense is serious, unquestionably, and we want to know where people who have committed sex offenses are located, the whole purpose of the registration requirements. I think in this particular case, the court has to look at the fact that Mr. Johnson was transient at the time of this incident.
Let me, I just a food for thought. That's not a defense. And a transient is the most, it makes the whole rules of reporting requirement, which are necessary for us to know at all times where you are. That makes him really anonymous now. And so transient status, I know people sometimes are in that status, but we the people have a right to know where offenders are at all times. And just because you're a transient is not. Yeah, that's the most vulnerable. Those are the hardest to find and locate. And that is still the onus, and the obligation is on the defendant, even as a transient. But being a transient, we lose track.
Indeed, it is
Okay.
on him, Your Honor, and it's not a defense, which is why he's pled guilty to this offense.
I know, but being a transient is makes him the hardest to find and locate. When the people have stated they want to know where sex offenders are at all times.
And I will,
Okay.
Judge, I just do want to note too that the law contemplates registered sex offenders being transient in a way that doesn't for any other law. There are special rules for being transient under Chapter 62 that could apply to him to take that into consideration had he been keeping up with his reporting requirements, which he's been required to do since 1978. I mean, this is not something new to him. That's when he received his conviction for indecency with a child. He should be well familiar with the rules. That's what his history shows.
87.
Oh, the offense date, I'm sorry, was 1978. You're right. He was convicted in 87. The offense date was 78. Either way, I mean, 30 years of plus of reporting.
23 and 19, that's 36 years.
So, I mean, there are rules within Chapter 62 that do apply to registered sex offenders that take all this into account. Even though it's not a defense, their requirements can be different.
He pleaded guilty in 2015. It says failing to comply with sex offender registration filed in 14, but he pleaded guilty, it says, to a lesser
To attempted.
It was an attempted failure.
Yes, sir. That's what
Okay.
he pled to, was attempted
Okay.
failure,
That's-
and then got 180 days state jail for that.
and
I'm
Judge,
sorry, 180 days county jail under 1244.
All right. I guess there is a way of attempting to fail. Huh?
well,
I just-
registering since
I'd
1987.
like one day when we don't have anything else to do to just open our minds and try to figure out how that is humanly possible. But nonetheless, it's what it is. That's a subject for another time. But go ahead, Mr. Wilkerson.
Well, I was just going to note, Judge, registering since 1987. It obviously he's had other offenses between those times, Your Honor, and times that he was incarcerated. But he has kept up with his reporting requirements for a vast span of years.
When it comes to, but that's fine. I know the point you're making is, so he stumbled a little bit, but in this type of offense, stumbling the people, the lawmakers and the courts don't want a glitch in when you have a sex offender who is required to be, whose whereabouts are supposed to be known at all times, and then there's a gap. Anybody feel safe? No. And that's a problem. And that's why there are gaps in doing the job that you're required to do are not excuses. You have to figure them out. And being a transient is the worst. Now we don't know where he is. So, I mean, somebody want to go on television and go, there's a sex offender somewhere in the town. We don't know where he is. Good luck, everybody. He's not reporting, and he's not, we don't even know where, because he's a transient. Well, the people are going to say, wait a second, this law is not working. Because we're supposed to be able to know where the persons are in this situation at all times. And it's their obligation, your obligation, even as a transient. But transient has no place of home, of residence. And you know, it's foremost is transient or not. He has to be known where he is, and he has to report. But transient, he's most likely to be unfindable, and that's even a greater problem
I will note to his credit, he has maintained the same line, the same phone number, same line of communication so that he could be reached at any time by his registration officer. I'll note that to his credit, Your Honor, so that he could be located in some manner. He did fail to register. He did plead guilty to this offense. I know the court would probably be loath to consider it, but in this particular instance, perhaps deferred is an option because it would follow the agreement. And if he did violate, then the agreement has been followed. So the court would be then allowed to sentence him anywhere within the range of punishment for this offense, anywhere up to 20 years if he were to violate probation. I think that he would admit that perhaps drug use compounded with problems and was an issue with regard to this, and therefore perhaps
Are you helping him now?
perhaps some treatment would help him ensure that he could meet the requirements that he's subject to at this time, Judge.
What state?
Judge, we're going to ask for the court to sentence the defendant to 4 years in TDC.
What would you like to say, sir?
Thank you, Your Honor. Your Honor, I know I did mess up and I'm actually going to be lenient, but Your Honor, I talked with Ms. Banks and she says there's a special needs program.
You talked to whom?
Ms. Banks,
Thanks.
yes, she said there's a special needs program that I could qualify for, because even if I did go to prison, get out, I'll still be homeless. But with this program, he said that they could get me housing, help me get housing. That way I won't, I can be located at all times. But right now, if I go to prison, Your Honor, I'm get out, don't have the same problem. But with the help of Ms. Banks and the probation,
Why can't
they're gonna do that.
Why can't you get help?
Well, now
Without
that age
being on
where
probation. There are.
with probation, now I'm of age where I can get into a senior citizen's place, and that's what Ms. Banks said they would help me with this special needs program that they have.
I believe he's stating it's a program through the probation department specifically, Judge.
I mean, Judge, everything that the defense is saying is putting the responsibility for the defendant's registration on other people, on the Port Arthur Police Department, that he had his phone number so that, Detective Hebert could contact him at any time, when that's not Detective Hebert's responsibility. It's the defendant's. I mean, it's nobody else's responsibility to take care of these things, but the defendant. So that's my concern, is there's no responsibility for the defendant here.
Okay. We sentence him to 4 years and then he gets credit and he's out. So, because he's got 495 days, and it seems like logically he would probably be released based upon the time served. What methods are available? If that was done, what options are available in the community for this defendant to go to and follow up on his requests without it being a probation order that is already there for him? What do we do?
Judge, I don't really have the answer to that. If he's sentenced and released on parole, parole would have resources to be able to help him.
That's true.
But
that is true. So he would be on a parole, and the parole people here, I understand, are pretty good about helping folks as though they were on a term of probation. So that is where, if that's what the court is, if that's the avenue the court takes of sentencing you to flat time under this agreement, and then you are released, but you're under parole, obviously it's like probation in that there are going to be parole conditions, and that's what you need to convey to them if they don't otherwise know that you're asking for some help to get your obligations accomplished. And I don't see why these other programs that you're asking for cannot be applied as a parole condition. Because if you fail on parole,
I,
You know, that's,
I would note to the court that, the court would have a longer period of supervision if the court were to place him on probation, than if he were paroled out.
well,
And
here's in response to you, if you're trying to look at what ramifications, or if you're trying to say, well, there's more of a hammer over his head because I can sentence up to 20 years in prison for a deferred or unadjudicated probation violation.
yes,
If he committed another felony, he's looking at habitual felon status, isn't he? Or close to it. Is he not?
Should be.
he's got several state jails. He's got ag robbing and decency. Yes, Your Honor, he would be looking, and the failure to register, he would be, if it were.
This would be his second TDC.
So,
yes.
so this is a,
But it depends on the
this
type
is a
of
second degree
offense.
felony. It would be enhanced to a first, the next one could be enhanced to a first degree felony punishment, which is deterrence enough. You're looking at life imprisonment if you get another one. So that to me is a motivator to get the job done. And I think the parole people can help them. All right, if nothing further, I'm going to find here, Mr. Johnson, you pleaded guilty voluntarily. You were mentally confident to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your plea hearing to find you guilty beyond a reasonable doubt. Now, I find you guilty beyond a reasonable doubt of this second degree felony of failing to comply with sex offender registration requirements. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years, and you will be given credit for all time you have served, which is unofficially at least 495 days. So that should help you out on where you are on being subject to release on parole. But then you must comply